civil courts, and for the most of the victims, that time has already expired. So now when they are coming in front of our court, we could not find, that something with statute of limitation is really so wrong that we would find a violation of the human rights. So I'm telling that really when you are drafting the law, you have to take into consideration all these issues, so statute of limitations, whether you have the systematic program that is not related to finding the violation by the courts that really the war crime has been committed, and to grant the possibility to all victims to get something. It should not, it could not most probably be to get complete compensation, but to find some good solution in this respect, that everybody could get something. I think that would be great if it is possible. But I'm opening the floor now for the discussion. Whomever.
Hello. My name is Noelle. I work with the UN Refugee Agency in Ukraine, and we're heavily involved in doing shelter reconstruction in eastern Ukraine. So this is highly relevant to our work. And I think what you just mentioned about the statute of limitations is certainly a concern in Ukraine, where, as I understand it, that there is a 3-year statute of limitations relating to applications for compensation under the terrorist-related legislation that will expire very soon, and there is absolutely no way that any significant number of property claims will be considered before that elapses. So if there is going to be any compensation for housing, there has to be an alternative mechanism that is established. As the colleagues have pointed out, that there is a reluctance, a political challenge about adopting this legislation on compensation, which is also linked to resources. And the nature of the conflict in Ukraine and the level of damage that's been caused means that compensation is expensive, and it's expensive in a country in a time where those resources aren't available, and where up to now the international support has not been there to compensate for that lack. So I was interested if perhaps I'm expanding on the last point that you were raising about partial compensation, something that would help those families who have the greatest needs, who've had the greatest destructions, whose houses, I'm also cognizant of the fact that we're repairing houses every day. And some houses are being repaired. And I don't understand how that would work. I mean, if the house has already been prepared, say, by an international organization, it seems that person should not be prioritized for compensation compared to someone whose house has not been. I mean, we tend to do the easy cases, the people who just need a little roof or a little something, because we can make our resources go much further that way. But there are houses that are totally destroyed, and which are more expensive and to rebuild, and humanitarian action simply can't cover those sorts of expenses. So if you could reflect a little bit about this tension between principled action and also the pragmatic of actually giving of being able to do compensation in a resource-poor environment.
Gulara Gulieva, University of Birmingham. I've got a question to Antal and Vito. And while it's obvious, and I do turn to the European Court of Human Rights for solutions as well, how do you suggest that we overcome resistance of some states to implement the decisions of the ECHR? Looking, for example, at Cyprus versus Turkey, where there were 90 million euros awarded to victims of a conflict between those countries. The decision remains unimplemented. Let's say the court awarded those damages and demanded that Russia pays money which would go to IDPs. What if Russia refuses to pay that? Then what? It undermines the ECHR mechanism, but also doesn't offer solutions. Any thoughts on that particular issue?
Okay. So I think we start with you, and then we can go to the question. Okay, but we will continue, of course, with the question.
Thank you, Gulara. Excellent question. I limit myself to the implementation. Yeah, you're absolutely right. The limits of those cases, especially the highly prioritized and politicized cases, is really the implementation. Whereas many of those cases rested and have remained unimplemented, especially Cyprus versus Turkey, the recent Katan cases about Transnistrian language education in Transnistria, Moldovan language education, or the Moser case, also still unimplemented. There is a higher, at least a higher chance to have implementation and proper compensation in the individual cases. That happened in the individual applications. The Xenides Arestis has been partially already implemented as regards the compensation for loss of property. But you're right. So it is for the. I don't have a solution. It is really for the Committee of Ministers and political solutions. Maybe the European Union could intervene by pressure on Turkey and the similar issues with the Ukraine versus Russia case. Thank you very much.
Thank you. Yes, thanks for the question, and I agree with Antal that is a very complicated one, and I also don't have really a clear answer to that. We had the problem of implementation of judgment, for example, in cases related to Chechnya, and because many times the court requested, found a violation by Russia, for example, to the procedural aspect of Article 2, so the fact that there hasn't been an effective investigation into violations, and they found that in a number of cases, and we still have the problem that Russia is not implementing it. And this certainly undermines the whole possibility for victims to get reparation. And in a way, it's similar to what happens with humanitarian law that, I mean, it prescribes states to follow some rules like distinction or take precaution or to avoid collateral damage, but at the same time, states are still breaching these rules and we have no mechanism to really force them to do it. And so probably here is where the sort of the law ends in a way and politics starts, in the sense that the law can't really in itself oblige a state to comply with it, and then you need politics to weigh in and to do something. So it could be the Committee of Ministers to start to find new solutions to implement the judgment of the European Court, or pressure from other states, because otherwise I don't think that the law in itself can solve this problem, unfortunately.
May I add a remark? Professor Turkovic? For the first, just a small remark. The court itself could make the courageous step to, in case of ongoing, continuous violations, to open a new case. This happened with the very unique Ilashku cases, where one of the applicants remained in custody and not liberated by Russia. And instead of leaving the decision to the Committee of Ministers, the court opened a new case, the Ivantok case, and it has led eventually to not just for the liberation, but for the compensation in that case. So especially for ongoing violations of Article 2, 3, 4, related to the physical integrity of the person, I think that could be a courageous judicial activity. Thank you.
Works? Yes? Okay. Talking about first and answering the first question, just should comment. I think the question was about the portion 8, right, by the different institutions, particularly European Union projects. I think it's really important. It can help, because it helped not to delay with the human rights violations, and to create as much comfort as it possible for the persons who are victims. And talking about the legislation instruments and the draft law, we know that already there is a draft norm that compensation will be denied if the beneficiary received an insurance for the damaged or destroyed property. So maybe I think it's worth maintaining in draft law, in future law, to describe a mechanism of cooperation with different institutions and different investors which can help to resolve this issue, and it, as I said before, it must be a systemic approach to decide. Thank you.
We have a question. Yeah, and then
Is it working? Yeah. As my name is Ileana Posto, I'm a former agent for the Republic of Moldova, dealing exactly with those cases. Catan was my first case, and well, thereafter I had Moser and so on. And well, the outcomes of the cases you probably know, because Moldova was found as complying with its positive obligations. So, well, I see these comments exactly from the opposite point of view, as the Honorable Judge said. It's interesting to see what are the comments, not only from the part of the court, but also from the part of the government be held responsible. I don't have question, I actually have some short comments, because my tomorrow presentation will have the scope to find this solution inclusively on the implementation of the judgments, because imagine that those cases, even the Lashku case, if you will see, Ivan Tok case, was not implemented except those payments such as just satisfaction, and I think that Russia was considered because of Ilashku case that it paid those compensation, and it considered that it was its failure, and thereafter it will never implement Catan and so on. Well, it is difficult question how to implement, and it is difficult question what are the remedies, and whether in the Ukrainian situation what are the extent of positive obligation of Ukrainian. Because we discussed of these draft laws as a compensation of property issues. By the way, in Transnistrian region, it is also the problem of properties. We have among those 30 cases, you indicated 30 cases, there are already about 100 cases, just they have not been communicated yet. But let's say, for example, there is a group of cases where there is almost 30,000 of applicants unable to use their property in that region. So we have issues with property also.
I didn't say we don't have issues, but we don't have any decided case.
I just, my point is that the remedies in these situations of conflicts, pending conflicts, in our situation it is not pending, fortunately it's not pending, but it is frozen. And it well developed in another very difficult issue which was dealt in Moser. It was unlawfulness of those regime and the creation of systemic problem that the person detained under that regime, all judgments and so on, seizing the properties and so on, they are unlawful, which I don't know which most probably will be in the eastern part of Ukraine if those so-called de facto authorities will claim their legitimacy. So this unlawfulness will be the problem for Ukraine to deal with in the future. In Crimea it will be a slightly different question. So my point is when we're discussing about the remedies, we're discussing not about the remedies on property issues. We're discussing about the general remedies, the general approach. It is about attribution between the responsibility of the states, because why it seems that why Ukraine at the moment it's a little bit reluctant to introduce some remedies, because it still has to observe what are the extent of its positive obligations towards those territories under no effective control, and what are its positive obligation in Crimea. So without a decision, without a judgment from the European Court, which would retribute responsibility between the states, we cannot talk about the remedies. This was the scenario in Cyprus versus Turkey. It was Louis-Zidou dealing with jurisdiction. Thereafter, it was Cyprus deciding about the remedies and application of Namibia exception. And thereafter, the Turkey know what is positive obligation. And after the last case, yes, this is about cooperation between the states pending frozen conflicts. So now, after this retribution of the responsibility between the states, only thereafter the Ukraine could, be aware of the extent of positive obligations. And of course, implementation. Implementation is a political question. Okay, I agree, because I pleaded before the Committee of Ministers, and I know what are the discussion about this, but the implementation of the judgment depends on the attitude of the state. And the court here, at least my point, and I will try to settle this point tomorrow, the court should deal and should convince the responsible state that it is in its own interest to implement. So here we will have, for example, an interstate application in Ukraine. Ukraine will be dealing to implement its judgment and its obligations, even towards those applications, individual applications that are, lodged against Ukraine. I call this quasi-interstate application. But the court should convince Russia that it's its own interest to implement its judgment. This is a difficult task for the court, for a moment. How it will deal with it? Okay, this is the court, the European court. Let's see tomorrow. I don't know. Thank you. I'm sorry.
Thank you for the comment.
Too long comment.
Down, bottom. At the bottom.
Okay, so my question goes to Antal, and this is more practical about pilot case. I would like to ask about the momentum to use to institute and initiate such proceedings in terms of Ukrainian conflict. For example, if we are talking about property compensation, at the national level, we evidence the situation that there is no possibility to apply and win the case if there is undocumented damage. I mean, the territories that are very close to the front line, this is so-called the gray zone, and there is no possibility to document the damage caused. And this is why people are waiting, and in the meantime, this limitation period is expiring. And might it be a successful factual background to initiate such pilot case for Ukraine, for example, for those people who are staying there, who are suffering, but they cannot effectively use domestic remedies?
Okay, yeah.
I may answer in the context of ongoing reform of procedural codes, of procedural criminal and civil and administrative, not criminal, sorry, administrative and civil and commercial code of procedures. There is a new, it's innovation, a new norm, which stipulate that the courts of first instance, if they have more than 10 typical cases, may apply to the new created Supreme Court with such a, so to speak, pilot case or for pilot procedure, and the Supreme Court may decide on such a case to show the general approach to such a typical problem. So it may be, it has a perspective to be used in Ukraine according to the new code of administrative procedure. Just a small comment.
My name is Olga Karenyuk. I represent Women's International League for Peace and Freedom. This is the oldest women's organizations in the world. So I have, thank you very much to all speakers for very interesting presentations, and as it was mentioned in the last presentation, that the issue of remedies and reparations is not, there is no dialogue in this society in Ukraine. Government limits this discussion only by the terminology of IDPs, internally displaced person, and IDPs for the government is only those who are registered. And even only during the last month we had a discussion that those people who live in the gray zone and their houses were destroyed, but they were not internally moved and were not internally displaced, only that to grant some status for these people also. So there is no comprehensive discussion and approach from the government about the term who can be considered the civil victims of war. And this is very important because government, in terms of in historical perspective and also in terms of further reconciliation and reintegration of these territories, because government already introduced some legislation acts. Of course, maybe they are not very efficient for compensation for military people who died during the conflict, but there is no any legislation act which protect civilians who were killed in their gardens or in their houses. So in this regard, of course, we hear from the government two magic phrases which excuse everything. There is no money in the budget, and the second, these are IMF conditionalities. So that's why we increase prices. On the other hand, government is effectively fighting against the application of the law on combating terrorism. So we already had, I think, several cases where judges on the regional level, on the level of court of first stage or of a court of appeal, made such decisions which are to satisfy the claims. But the government, the cabinet and ministry applied to the Court of Cassation, and the Cassation Court cancelled these decisions. So these cases are still under review. The responsibilities on registration of destroyed buildings and destroyed properties are put on the very local level. And I think even there were some instructions already implemented that local authorities are responsible for documenting of these destroyed buildings. But this is not very effective because they are doing this on very low level, even comparing how Russian Federation is documenting destroyed houses on non-government controlled areas. So the question is, what would you say? If we took away this question of money and look at the situation in historical perspective, what would be the ideal steps of the government to implement in terms of to accept this, to introduce this term of civil victim of war, to take into consideration not only destroyed property but also civilians whose relatives were killed or who had some physical injuries, and also people taking in consideration people who were detained in this place of illegal detention. Thank you.
May I answer? Because just the time element, very crucial. Thank you for the question. I think there are two different questions. The time element in improving the title to the house and to proceeding before the court, and the time element for opening pilot procedures by the court itself. As for the evidence, I think the court has been quite recently very, very flexible in accepting documentary evidence, especially in the two Nagorno-Karabakh cases, the Sargsyan and Chiragov cases. It accepted the applicants to substantiate the title to the house, the damage or the lack of access to the house, even without any documents, which the IDPs, the concrete case, have absolutely lost during the displacement. And even the court was even willing to ask for satellite experts to have an overview about the housing situation of the concerned areas. So in this case, I would say that for applicants, the best way is to proceed as far as domestic remedies have been exhausted and substantiate their claim, the title or the access to the house. As for opening the pilot procedure, that's a very difficult question. I would have difficulties if I were the judge in the court. What the court has done until now in pilot procedures is to wait until a substantial number of applicants claim for the same structural or systematic problem in the domestic law of the given court, and or the given legal practice in the given court. But it's certainly not a question of number of applicants. In the first pilot procedure in Poland, there were more than 100,000 applicants, whereas in one French case about I think property compensation, it was just 12 cases which the court suspended for a pilot procedure. It's rather a question of identification of the same existence of structural and systematic problem. Thank you. Thank you.
Anybody else? Do we have any other question? Okay. I will conclude this session. I would reflect like this. Many very difficult tasks in front of our court, and lots of hopes, and eyes that are looking at the court. Many cases. We are again approaching 100,000 cases. We have decreased to 60,000 cases. We are close to 100,000 cases now, at this point, mainly due to Turkish cases that are coming daily. 500 to 700 cases are coming from Turkey daily, and then Ukrainian cases. Not on that scale, but still a great number of Ukrainian cases that we have. The court from inside is trying to develop new mechanisms, new ways how to improve its own efficiency. As you know, we cleared stuff with single judge cases. Now we are looking at the repetitive cases and how can we deal more efficiently with repetitive cases, or with the cases that are dealing with the same issue. And you will see very soon that a great number of cases that were dealt up to now in front of the chamber of 7 judges will actually be moved at the level of the committee cases and will be dealt with the committee of 3 judges. And not only cases that are just what we call Weckl cases, or where we have a well-established case law, But even the cases where, for example, for a country, for the first time the issue appears, but this is already well-established case law in some other countries, it will come. And it will be not only limited to, I don't know, Article 6 or Article 2, Article 3. So, you know, like these really fundamental rights will be dealt with committees, just in view to, you know, make our work more efficient. And we are looking at all other different, you know, ways how we could improve speediness, how we react, you know, and you were talking about that. So this is one issue. Second issue is, if you are really looking what is happening in the societies, in the European societies nowadays, then you can see that change in the perspective what court should do and how court should be used. And that's why I appreciated yesterday's movie and the discussion and what actually Philip is doing. And he mentioned that in his, and I will talk a little bit about that tomorrow, I suppose. You know, how to promote the court and how to protect the court in a way. And I must say that, protect the court, because it's really what is needed nowadays. You see, when Brighton started, it was said that the court is victim of its success in terms of the numbers, you know. But the court is not only victim of its success in terms of the numbers, but in terms of the rights that it is delivering. No? Yeah. So it is thought nowadays, if you are reading carefully the discourses that are going around, that the court is guaranteeing too much rights. And the states are backlashing. So it's interesting to watch, and that is what Philip yesterday said, and that is, I was thinking about that before, but that is just prompting me to say something about that. He said, writing a book like that is doing more for the human rights than what the, you know, lawyers can do in their regular work, because the community as a whole, the societies as a whole are becoming aware how that is important. And I think that we are at a stage where we have really to question ourselves. Sovereignty of the state, you know. The states were willing after the Second World War to limit their sovereignty. And so many years have passed after the Second World War for many states that didn't have war on their territory in Europe. Some had, unfortunately. And those states most probably have different views from the other states. And I always have the feeling nowadays that through the discourse of subsidiarity, we are coming very close to the discourse of sovereignty, you know, and that the states are somehow trying to regain more and more sovereignty from themselves that were taken from them, and to a great part through the European Court of Human Rights. So you see, these are all these things that are going around, and we have to be aware of these things. So how far the court could go, what are the limitations that the court is facing nowadays, and what the hopes, you know, are also doing to the court. And when we are coming to the subsidiarity, that means that more and more responsibility is put on the shoulders of the national authorities. And the more and more is required from the national authorities. So I know that from the political view, what you have said, it seems reasonable for the state to wait to see how the court will, I don't know, distribute the responsibility. But I would say differently. As in a criminal law, you know, we say criminal law is ultima ratio societatis. European Court of Human Rights and different international instruments actually for the states should be ultima ratio societatis, and the states should be responsible to start to deal with the problems themselves without waiting and losing the time to come in front of the court for the court to find the solution and then having the problem of the execution. And court is very careful with the execution, and court is really looking very careful. Judges are looking really very careful. Is it a right moment to give certain judgments? Because non-execution is really questioning the legitimacy of the court. And if you are looking at the execution, then you see that you have the states that are executing very well. You know, we are talking about Great Britain and the problems with the execution, but this is only one case or eventually two cases. Otherwise, they are executing promptly. And then you see that you have a bunch of states, number of states that are executing promptly. Then you have states that are executing promptly just satisfaction, they are paying, but when it's going to the general measures, then they are not executing. And then you have a certain number of cases that are not executing almost at all. And this is, of course, a political issue. And of course, that this is the problem for the court. But as some have said, the court might resolve. No, the court cannot resolve that. That's the problem. The court cannot resolve that. Now we have in Grand Chamber one Ukrainian case when we are dealing with the issue. No? But it is difficult for the court to resolve that. It's almost impossible, I think, for the court to resolve that. And it will be most probably mostly on the states and on the Committee of Ministers and on different kinds of pressures to help the court actually to execute the judgments that we are making. Thank you.
Не пойму, это конец или будет еще перерыв, еще? Ты выключил звук, да? Правильно.
We will start.
Идет трансляция?
Sorry, excuse me.
Виталик, звук нормальный?
So thank you very much. We have to continue. The time is precious, and our program is packed with very interesting and very different events. So now we have presentation of the book. We have only half an hour. And it's a real pleasure for me to introduce to you Sergei Sayapin, who is assistant professor at the program and the program director at of the international law at Kimep University at Republic of Kazakhstan. And we will have actually the possibility to listen to the book presentation that is still not published, but it will be published in 2 months. and that is speaking about the situation in Ukraine since 2014, jus ad bellum, jus in bello, jus post bellum. And the author will describe us what we will be able to find in the book, and also he will raise some questions that I hope will provoke some discussion. So floor is yours.
Dear colleagues, good afternoon. I'll take several minutes to talk about this book, and we'll finish at 17:15 sharp in order to proceed to Professor Vasilny's lecture. So there will be a book. I am not the author of the book. I am one of the co-editors. At the time I applied for participation in this conference last autumn, I hoped the book would be out by the time of the conference in order to be able to present it here. But as it happens sometimes, some submissions were late, so the editorial process took more time than expected. The book will be out within the next 2 months. I'm hoping to submit the materials to the publishing house sometime in mid-June. And I still think it is an appropriate occasion and an appropriate venue to let you know about the publication of the book, since it will be destined to academics, to practitioners, to anyone concerned with the international legal dimensions of the situation in Ukraine since 2014. Well, as a matter of fact, this book is a personal story. A personal story in the sense that when the Euromaidan protests started in autumn 2013, I must admit I was somewhat indifferent to them. Because I considered those protests as a domestic affair, as an essentially internal affair of Ukraine, and as an international lawyer, I must admit I did not feel concerned with them in autumn 2013. But as with the developments that took place in early 2014, well, I felt that I could not remain indifferent any longer. Well, those events coincided somehow with a change in my career. At the time, I was working at the International Committee of the Red Cross, and the apolitical nature of that organization, of course, would not have allowed a project like this to materialize. But in February 2014, I already knew I would join a university, I would have an academic position, and so I thought of that a book project like this would be useful. I would like to take this occasion to thank Dr. Gnatovsky, who was supportive of the project from the very beginning. And it is to a large extent thanks to him that the idea of the book materialized. So the book will be published. It will be published within the next 2 months by TMC Assa Press and Springer. It will consist of 3 parts, because each part respectively being devoted to the jus ad bellum, jus in bello, and jus contra bellum, these aspects going together as the relevant parts of international law. As of now, I'm expecting the book to consist of 28 chapters, plus there will be some appendices containing documents, various resolutions, other official documents pertaining to the book's subject matter. And from the very beginning, I thought of the project as an international project. Why so? Because within Ukraine, of course, there are numerous publications on the subject. There is an excellent monograph, Revolucja Gidnosti, that cannot be surpassed in quality. There are publications in the Russian Federation that obviously represents, or most of which obviously represents, the official position of the Russian Federation on the matter. So I thought that the project should be international in as much as the conflict in Ukraine and involving Ukraine, it has a very large dimension. It concerns states in the former Soviet Union, in Europe, but it also concerns many other states. So here you see the nationalities of the contributors to the book, which shows that what is going on in Ukraine now is felt. And this morning there was a discussion about feelings, about the role feelings play in personal and professional consciousness. So there are many people who are taking the developments in Ukraine as a matter of their profession, but also as a matter of their feelings, and they decided to contribute to the book. Let me give you a brief overview of what the book will be about. In the UGSPL part, there will be chapters dealing with, for example, the legal nature of states' obligations towards Ukraine in the context of jus contra bellum. There will be a chapter dealing with aggression as not only a use of military force by one state against another, but as a toolbox. In fact, as a program of activities that is becoming topical in the context of hybrid warfare. There will be a chapter by your obedient servant on the concept of patriarchy that I am trying to introduce since 2014. There will be a chapter on the applicability of the law of occupation to developments in Crimea. There will be a chapter on the legal status of the Crimean people, on Russia's official position with respect to protecting nationals abroad as an ostensible ground for an intervention in Ukraine, and chapters analyzing respectively the legal status of the so-called Donetsk and Luhansk People's Republics, more generally international legal aspects of Russia's war against Ukraine in eastern Ukraine, plus the applicability of responsibility to protect to the conflict in Ukraine. In the second part, various aspects of the jus in bello are dealt with, such as the legal qualification of the conflict in Ukraine, legal challenges associated with hybrid warfare, what it is, how is it to be understood and interpreted, this novel concept that became so topical in the context of this conflict. There will be a chapter on the operation of treaties and international contracts in the event of armed conflict. There will be one on the applicability of international humanitarian law to the conflict in Donbass, on cyber warfare, on volunteers on the battlefield, on foreign fighters in this conflict, on children in the armed conflict, on the occupation of Crimea, on criminal prosecutions of Ukrainian nationals in the Russian Federation. And this particular chapter is written by the defense lawyer who dealt with several such cases. Plus, there will be a chapter on historical memory. And in this sense, it's interesting for me to observe the links between the chapters and the various presentations that were made this morning dealing with this with various aspects. And there will be a third chapter on the jus post bellum that deals most closely, most intimately with the subject matter of this conference. There will be one chapter on reforms in times of war, on the possible regional reconciliation mechanisms. And it's interesting that Gerhard Kemp, a co-author of this chapter, is South African. So he is, we have spoken a lot since yesterday about South Africa's experience, and he and Igor Lubashenko are making interesting proposals regarding the applicability of South Africa's experience in other countries, including in Ukraine. There will be a couple of chapters on the ICC's jurisdiction with respect to crimes committed in this conflict, on sexual violence in the conflict, on the role of the European Court of Human Rights, there will be a chapter drawing parallels between the war in the former Yugoslavia and here, plus the role of the media in the post-conflict reconstruction. So the choice of the topics was obviously conditioned by professional interests and the expertise of the respective authors, but overall I believe the book will provide a comprehensive picture of what is going on in this country, and I do hope that ideally the book would be useful both to academics and to practitioners internationally. To conclude with, I would like to present to your attention 3 questions that I believe the book is about, and probably if we have time we could discuss them at some length. The book is about the models of transitional justice which are appropriate for Ukraine. And this is precisely what we are discussing here in over these 2 days. It is about the implementation of international criminal law in this country. In other words, did it become after the start of the conflict that Ukraine's domestic criminal law needed to be amended, needed the implementation of international criminal law, and if yes, to what extent? And thirdly, what are the lessons for Ukraine's neighbors to be drawn from this conflict within and outside Europe? Let me give you just 2 examples from Kazakhstan, from the country where I live and work. I am not a national of Kazakhstan. I am a national of Uzbekistan, but I'm now permanently based in that country, and obviously I'm interested in developments in that country. So, Kazakhstan is Russia's ally in the Collective Security Treaty Organization. It is Russia's ally in the Eurasian Economic Union, but still the position of Kazakhstan with respect to the conflict in Ukraine is interesting. It's noteworthy. Let me give you just 2 examples. Over the past year, there was at least 1 person in Kazakhstan who was convicted for participation in the armed conflict in eastern Ukraine. So that guy, he insisted that he did not fight, that he did not participate in hostilities, but he was simply a cook, so he said. But still, Kazakhstan's authorities were quite firm on penalizing his involvement to this or that extent in the hostilities in eastern Ukraine. So Kazakhstan wants to distance itself as a matter of practice from that conflict and does not want to allow its citizens to contribute to that conflict. Another example is that of the administrator of a group in the social network Vkontakte. That man organized a survey in the group of which he was an administrator. The survey was about the opinions of users about the feasibility of Kazakhstan's northern regions joining Russia. So he did not call upon those regions to join Russia. And you may know that in the north of Kazakhstan, firstly, the land border between Kazakhstan and Russia is the longest land border on Earth. Its length is more than 6,000 kilometers. Second, in the northern regions of Kazakhstan, there are many Russians. In some regions, there are more Russians than Kazakhs. So there are quite substantiated fears to the effect that if someone incites turmoil there, that turmoil might become quite important. So that administrator, he did not call upon anything like that. He simply organized a survey. What about the attitudes of users to those regions potentially joining Russia? He was convicted for that. So to conclude with, it's obvious that the effects of the conflict in Ukraine are more far-reaching than just within Ukraine. The examples from Kazakhstan testify to this. The range of authors, of contributors to the book also testifies to that. I am hoping that once the book is out, it could be useful for you, for your colleagues, and I thank you very much for your attention. Thank you so much.
Thank you very much for your presentation. Just listening to the titles, actually, I'm starting to be excited. And I think I would like to read the book, especially certain articles that you have mentioned. I'm opening the floor for the discussion if there are some questions. You told that there are a variety of authors. So they are coming from what kind of institutions, what kind of states? How did you pick up them? How you organized all of that? So.
Well, the authors come from 16 countries so far, and they are personal contacts, friends, connections of the co-editors. This approach was taken in order to speed up the work as far as possible. So there was, we opted not to make an open call for submissions, but rather we thought of who among our colleagues and friends might be interested in the issue, and we invited them to contribute. Most of them are academics, some of them are practitioners, and let me give you another example. All contributors somehow feel personally about the topic, about the project. Let me give you one example. There is one contributor from Kazakhstan who in a private discussion with me told me openly, there are colleagues who tried to persuade me not to participate in that project because they said it could simply be dangerous for me. That is for that author. But still, he said, I will participate in the project because it is a matter of my personal honesty. One day this will be over, and then it will be time to see who is who. So I was touched to hear that opinion from a colleague of mine who is quite high-ranking in Kazakhstan. He's a vice rector at his university. So in fact, he's risking his position by contributing a chapter. Still, he decided to do that.
Thank you very much. So we have 3 questions that you have posed. Do we have some additional questions from the audience? Or some reflections on the questions? Yeah. No, maybe.
I'll give it back, of course. My name is Taras Tymbrivsky. I come from the Ukrainian Catholic University. I have perhaps more specific question addressed to Professor Sayapin. In your opinion, what are the challenges in recognizing a Russian Federation as an occupying power in terms of the conflict which is taking place in the eastern Ukraine? Especially in the question of the attribution of the proxy warfare.
Well, I believe there is no challenge if you take a positivist approach. In terms of applicable positive law, there seems to be no particular problem in qualifying the Russian Federation as an occupying power, inasmuch as military force was used in Crimea and in eastern Ukraine. In accordance with applicable law, an occupying power is that which exercises effective control over a certain territory, and that is what we have. However, the challenge that is there is one of hybrid warfare. That is the challenge of denying facts, the challenge of distorting law, the challenge of misinterpreting provisions of law, the challenge of inventing new law and here I mean the so-called Crimean law. This is a phenomenon that emerged since 2014 in order to explain and justify the developments in and with respect to Crimea. So the challenges I see are not those of law. They are of politics, of public relations, and of misinterpreting and misapplying the law.
I want to add to the question. I work for the foreign ministry. I'm not a lawyer, and I have a question to lawyers presented here. In the second resolution of the UN, Russia was recognized as occupying power. Please correct me if I'm wrong.
It is so indeed. However, there is there's a problem about the legal force of that resolution. As a rule, resolutions adopted by the General Assembly of the United Nations, they are not as such regarded as having a legally binding force. However, and this relates not only to this resolution but also to the very first resolution of the General Assembly that was adopted on the 27th of March 2014. I believe both this and that first resolution, they do have binding legal force, because both resolutions contain norms of international law that would otherwise be binding. That is, they make references to other rules of international law that do possess legal force. And this fact increases the legal force of these resolutions themselves.
Do we have any other question? I have a question. What is the problem with the Ukrainian law in terms of the international criminal responsibility? So what is missing in the Ukrainian law to be able to punish for the crimes that are committed during the conflict?
Well, probably Ukrainian colleagues would be better qualified to answer that question. But remember, in October last year, there was a roundtable at the Institute of International Relations that dealt exactly with this issue. At that roundtable, I shared my views on the utility of developing at least the Ukrainian criminal code's provision on the crime of aggression. I believe that that very provision could be updated. But also on that very occasion, I heard that there was work going on in Ukraine regarding the development of the provisions of the criminal code dealing with war crimes, with other crimes under international law. And unfortunately, I am not presently aware of the outcome of that work, but hopefully that work will be brought to an end.
Okay, thank you.
Just a short question. Why Ukraine? Why now? And whether you consider in perspective, because the last question of the effects of the Ukrainian conflict on the neighbors, whether you consider in the perspective reflecting on other long-standing conflicts, Georgian conflict, Nagorno-Karabakh, and of course Transnistria, which is closely connected to my country. Do you consider in exploring or extending this project? Because from my experience, I see for the first time, let's say, as an overall approach on one particular topic from different points of view, because those conflicts were reflected, but let's say separately by international humanitarian law, by human rights law. This, am I correct? This book has an overall approach from universal international law perspective, and whether you consider extending this project, because if you considering, I will be happy to attend to it eventually. Thank you.
Thank you. So why Ukraine? Because, well, as I said earlier, it was a personal story. I mean, I do feel emotionally connected to Ukraine, although I'm not Ukrainian. So, professionally speaking, what is the developments in Ukraine? They have a more far-reaching effect than only for Ukraine, than only for the Russian Federation. This is not a bilateral affair. This is a situation that affects neighboring countries, both at official levels and at the level of simple people like anyone in this audience. What do I mean? I mean that because of the situation in Ukraine over the past 3 years, people are losing friends, people unfriend their friends, people are making new friends. The situation in this country has an effect at a distance of thousands and thousands of kilometers. I'm being serious. In the country where I come from, in Uzbekistan, and in the country where I am living, in Kazakhstan, societies are literally divided over the conflict in Ukraine. People are taking sides. People make friends and unfriend people because they truly feel they can no longer be friends with someone who is of another view. And yet there is another important point. The situation in Ukraine is a challenge to international law. It prompts politicians to rethink the application of international law, and it prompts academics to rethink the teaching and the very essence and philosophy of international law. I remember when I joined KIMEP University in 2014, it was the beginning of the conflict. Some of my students told me, like, are you going to teach us international law, but it's not working. The international law that you want to teach us is simply not working. Look at what's going on in Ukraine. Sometime later, I was able to tell my students that by contrast, international law is working. So, yes, it is a time of challenges. It is a time of rethinking and reshaping. But as such, as a phenomenon, international law is withstanding the challenge. It is responding adequately to the challenges of the time, and it is becoming stronger. So, to conclude my answer to your question, I believe that this conflict will make a better international law with our contributions.
It's a nice sentence to finish the this.
Thank you very much, dear colleagues. Thank you.
So now we will have, I don't know what's the time because I don't have the time. Is it? Yeah. Yeah. So I think we will have to, I don't know, we have it in this room or? We have it in this room, Professor Basionis? It should be in this room, okay. We have time, or we have to stay? Okay.
Наталья, не выключай. Не выключай.
Dear colleagues, can we start now?
Тестирование, Виталий, ты сказал, что хороший. Мы должны тогда были сказать.
Dear colleagues, may I kindly ask you to be seated because we have the next point on our agenda, and we are particularly privileged today to have conversation with Professor Sherif Basiouni. Of course, he will appear via Skype. I will explain to you why. But firstly, just a short introduction. Of course, I'm sure you all have heard this name. Sheriff Bassiouni is often referred to as a father of international criminal law, and this has a very good reason. He had played key role in drafting of almost all the major criminal law instruments developed in the last 50 years, including the Torture Convention, the Rome Statute, the Apartheid Convention. And without his contribution, undoubtedly, international criminal law as a distinct discipline we recognize today will simply not exist. And of course, this contribution is highly recognized. Among his many distinguished awards, he had French Legion d'Honneur, High Praise for International Law, and he was also nominated for Nobel Prize in 1999 for his dedicated work establishing the International Criminal Court. Professor Bassiouni was born in Egypt into a politically active family. His father was a diplomat and his grandfather was a president of Egyptian Senate. Among things that formed his mentality, he used to mention one episode of his childhood. In 1943, as a 6-year-old boy, he overheard, hiding behind a cartoon, a conversation of a guest from Jewish agency who escaped Auschwitz and came to his father to speak about atrocities Hitler committed in Europe. And shortly after, when his father left, this little boy took his little toy gun and in the middle of the night went on the street with an intention to kill Uncle Hitler. And he was very upset at his mother who prevented him from doing this very good deed. As a law student, Professor Bassiouni tried to protect Jews targeted by Nasser regime. For his efforts, he was placed under house arrest for 7 months, and he lived in nearly total darkness because wooden shutters were nailed